Mr. Cooper doing anything to address Mr. McClain's statements here? I'm trying, please help me.
I do not recall.
Do you remember Mr. Jacuniak doing anything at this point in time to respond to these statements? I'm trying, please help me.
I do not recall.
Back now to the final trial tied to the death of Elijah McClain and the testimony given Monday by an EMT on scene. To every question posed by the prosecution, his response was the same: I do not recall. This morning, we are diving into the potential consequences of that testimony to the prosecution's case.
Which is why we're bringing in our 9 News legal analyst, Whitney Traylor, to kind of break it all down. Whitney, thank you for joining us this morning.
Sure, good to be here.
Okay, so first and foremost, what do you make of that response, I don't recall?
Yeah, I've seen that in a lot of different contexts, in depositions where you're preparing for trial, which is also under oath, and then, of course, in trial. And so here, I mean, this really highlights the importance of our jury system, because in our jury system, not many countries have that, and this is where you get to judge credibility. And so if somebody is, and you heard just there, even on the lead-in, he was almost answering before the question was finished. Hey, do you recall what? I don't recall. I don't recall. And that goes to the jury. And in closing, really a good lawyer is going to hammer that home and say, look, this case was so impactful. This was clearly the case that's gotten the most press they've ever had. And you're telling me that you don't remember the events of this evening. You don't remember one simple thing. So it really highlights the benefits of the lawyers being able to cross-examine and kind of illuminate the credibility issue. But it also raises the issue of, I mean, to me, if I'm watching somebody give the same answer over and over, rote, without even any emotion, I'm questioning whether they're telling the truth or not. And that is the whole point of a trial, is that you're assessing credibility.
So to you, with your legal expertise, this does create a credibility issue.
I think it creates a credibility issue. Now, I don't know why the prosecution may have brought him on, because sometimes in trial, it's to the layperson, they don't understand. So you might bring somebody on just to get one little piece of evidence in, and people may not even appreciate the importance of that. So maybe they were putting this person on for that specific, that little piece of evidence. But I don't know, because if it was a prosecution witness, you would think that they would be more forthcoming with their answers.
Right.
And what does it take to vet a witness for the prosecution?
Well, so criminal trials are different, because in civil trials, you're given the opportunity to depose somebody. So that means, like, they would come to my office, we'd have a court reporter, I'd get the opportunity to ask them questions under oath. So I know what they're going to say beforehand. You don't have that benefit here in the criminal trial, but I would suspect that the prosecution or their investigators would have talked to this person and known what to expect.
So what constitutes a hostile witness?
Right. So a hostile witness, that's something where, so let's say I call a witness, and I'm limited to direct examination, so I can't ask leading questions. But if the witness is not answering questions and they're not being cooperative, and it's clear that they're trying to avoid, you could say, Your Honor, I'd like to declare them a hostile witness, and then you can cross-examine them. And that's where really I was a little surprised that the prosecution didn't try to do that and say things like, sir, have you had a case that was this impactful to you before?
Yeah.
No. Was this out of the ordinary? Yes. But yet you still can't remember a single thing.
Yeah, and very briefly, Whitney, do you think this could impact the case going forward?
I think it could impact the case going forward, but I think the bigger issue here is really the cause of the death, and that relates to the timing of these trials, because in the first trials, the police, law enforcement were able to say, well, it was the ketamine. And now these guys are going to say, no, it was the conduct of the law enforcement officer. But unfortunately, those trials have already went forward.
Yeah.
So I think the paramedics are in a little bit of a disadvantage here.
Okay, Whitney, thank you so much for breaking that down. Certainly a lot of questions still with all of that. Thank you. Well,